Is the day I'm going to go over the new required paperwork based on the laws that have changed for conducting business based on the NAR settlement. Today is the 12th of August, and although the settlement goes into effect as of the 17th of August, all paperwork has been updated and released and is in effect as of August 1st. And so I waited until now just because there was all sorts of different changes that were fluid. They were constantly being changed. And this might not be, it very well might not be the end or the final draft or version that is come up with. There are 18 forms that are either new or changed. And so in this series, I'm going to go over those forms, understanding them, making it clear and and easy to understand. There is a lot of confusion, and so now more than ever, it is important that you, as a consumer, understand the paperwork that you're getting involved in and the whole entire transaction process. My name is Andrew Texador. My brand is Clearly Sold by eXp Realty. I've been licensed since 2000, so I'm going into my 24th year here in 2 months, and I make it a concerted effort, an intentional effort to help educate all my clients on all the paperwork, the process, so that when we get into the process, they know what to expect at the next milestone, and it's easy to keep moving forward, right? And so, with the changes, my concern is that a lot of people are thinking, "Wow, now I have to pay my agent. If I use an agent, maybe I won't use one." And so, that is a valid concern for you as a consumer, and I just want to help put that to bed and say, listen, you've always paid commissions. It just hasn't been presented to you that way. Okay? If you pay $400,000 for a home that the seller bought time before, and let's just say they bought it for $200,000, you are the one establishing the market on that home, right? The monies are all dispersed at close of escrow. There isn't a seller that I've ever known that has paid commissions out of their pocket in advance. All monies are collected at close of escrow. So whether you're a cash buyer or you're getting financing, it's your funds that come to close that pay pretty much everything. Okay, and there's people that will debate that, and that's obviously how we got to this point with this settlement and the whole lawsuit. I'm not going to go over all that because that's a whole nother bag of worms. But let's get right into this buyer-broker exclusive employment agreement. And I will just notice right up front, right up here where it says notice to buyer. All realtors are required to have a signed written agreement prior to showing a home to a buyer. This has been updated for August 2024. So if you hear someone say, hey, I can't show you a home without a signed agreement, it is the law. And the only instance that I'm aware of right now that this would not be applicable is if you were to go into an open house, okay? And so an open house, the agent that's working the open house is working on behalf of the seller. It's open, you're welcome to go in there, and you don't have to sign anything. If you are working with a realtor that's setting up portals, portal showings, if they are going out on virtual tours, if they're helping you shop virtually via Zoom or video while you are in another part of the country, you have to have an employment agreement in advance. Folks, this is to protect you so that you know what it is that you're getting into, who is responsible to pay who what, and so that you have a clear understanding of this up front. Many people didn't think that they were paying a realtor because the commissions weren't being paid directly from them. But I'm here to tell you, your funds to close escrow paid commissions, okay? And so we'll be talking, if you want to know more about all of the compensation is the new word. And so let's just get right into this. Where you see draft, that is the areas in this contract that can be information can be put into. All of the red lines are areas where there have been changes. Okay, so there'll be a buyer. There's a broking firm and the agent's name. There might be more than one broker in this consideration. The buyer broker exclusive employment agreement is between the buyer and the broker in consideration of broker's agreement to assist buyer to locate, negotiate, and facilitate the purchase of a property. Buyer gives broker the exclusive and irrevocable right to represent buyer in the purchase of a property during the term. Buyer acknowledges that signing more than one buyer broker exclusive employment agreement or similar agreements could make buyer liable to compensate multiple brokers. So this is very, very important. Basically, you're going to get into an agreement with one, in this instance, with the buyer broker exclusive employment agreement, you will be getting into an agreement with one realtor. If you get into an agreement with more than one realtor, you are potentially on the hook. This is legal and binding. This agreement shall commence on its given date, and based on, we're in Arizona, so it's Mountain Standard Time, and the expiration date. Your employment broker agrees to locate property meeting the following general description, okay, within a certain geographical area. And we as realtors are only to work in geographical areas of expertise. So if you were to come to me and say, hey Andrew, can you help me buy a house up in Flagstaff? I would refer you to someone that I am in a network with, but I don't know soil conditions up in Flagstaff. I don't know, I am not an expert in Flagstaff, so I wouldn't be the one to help you up there. And that's just it. It's not my area of expertise. I wouldn't be the one to give you the best fiduciary responsibility, and so I would go to my network. That's why I've got a network of other people I could refer you to, because I want everybody to have the best representation or the best chance at representation when they are getting involved in this deal and looking to buy or sell real estate. Okay, so then we go down to B on 15. It's negotiate the buyer's direction to obtain acceptable terms and conditions for the purchase, exchange, or option of the property, and assist buyer during the transaction within the scope of broker's expertise and licensing. The agency relationship between the buyer and broker shall be either A, set forth in the real estate agency disclosure and election form, or the other. In this case, I don't know why anybody would ever put other. I can only imagine ever checking that box on 18. Property viewings, this is important. Buyer agrees to work exclusively with broker to be accompanied by broker on buyer's first visit to any property. If broker does not accompany buyer on the first visit to any property, including a model home, new home lot, or open house held by a builder, seller, or other real estate broker, buyer acknowledges that the builder, seller, or seller's broker may refuse to compensate broker, which will eliminate any credit against the agreed upon broker compensation below. Buyer agrees to review the Arizona Department of Real Estate buyer advisory to assist in buyer inspections and investigations. There will be another video on that paperwork as well. Broker compensation is not set by law, nor by any board, association of realtors, multiple listing service, or in any manner other than as fully negotiated between the broker and buyer in this agreement. So there never was a standard amount of compensation, and there should never be. This is always a negotiation between the buyer and the principal. And then a retainer fee, if applicable, buyer agrees to pay a broker a non-refundable retainer fee in the amount of, and then that money, all monies would be going to the broker, right? So if I don't use a retainer fee, but if I were to have a retainer fee of say like $500, that would just kind of help the people realize that, hey, when you separate with your money, it gives you more you're more attached, you're more committed to that person. So, but the retainer fee would be made payable to the broker, not to the agent. All fees go to broker. Broker pays out compensation. And then it says the fee shall or shall not be credited against the broker's compensation below. Line 31, if buyer or any entity owned or controlled by buyer closes escrow on a transaction for the purchase, exchange, or option of a property, buyer agrees to compensate broker as follows. And then I just want to take a second and just go over this. There's a reason why it says buyer or any entity owned or controlled by the buyer. Okay? And that's because some people try to get sneaky, right? They'll do all this work and then they say, oh, wait, I can just, instead of me buying under my name, I'm going to go ahead and circumvent the realtor and I'm going to make an offer under my LLC. And so this is, and this is just stuff that happens in our life here. So, down to 33, check only one and fill in the compensation. So here's where you would determine the compensation that goes to the buyer, your agent, and it's agreed upon and put in here. It's either a percentage of the full purchase price, a dollar amount, but it has to be determined. It has to be fixed, okay? So if it's a percentage, that percentage can't change, right? Let's just say it's 2% of the full purchase price or exchange of value. If then you go and we're looking at a house and the seller is willing to pay 3% in compensation and we've agreed at 2%, that other 1% would go to you as a buyer towards your costs. Once we have an agreed upon amount of compensation, I can't change it. So I can't change it for a different property, if that makes sense. Okay, and not on this form anyway. The broker compensation shall be in U.S. currency and paid at time of and as a condition of closing for purchase or exchange, or as otherwise agreed upon in writing. Compensation from seller or seller's broker. Seller or seller's broker may offer compensation to broker. Buyer authorizes broker to accept compensation from seller or seller's broker, which shall be credited against broker compensation. If seller or seller's broker offer of compensation is greater than the broker's compensation, broker shall be paid the broker compensation and the balance shall be credited to the buyer. So that's what I just went over on the last page. Whatever the amount is that is agreed upon between the buyer and the broker is what it will be. Okay? 43, if seller or seller's broker offer of compensation is less than the broker compensation, buyer may request to pay the broker compensation as part of an offer to purchase the property. Any broker compensation not paid by the seller or seller's broker shall be paid by the buyer. Notice, unless modified by VA regulations, VA finance transaction shall be conditioned upon the broker compensation being paid by seller or seller's broker. This has temporarily been lifted. It hasn't been changed, but they are allowing, until further changes are made, VA is allowing that the buyers would be paying the commission. In this case, still, the buyer's agreeing to pay it, but the seller would be the one that is paying it on behalf of the buyer's cost in negotiation. It's kind of wordy, but you got to just remember, it's money in and money out. There's only two people that have money in the deal, and it's the buyer and the seller. And so it's going to come from one side or the other. Okay, so failure to complete. Once an acceptable property is located, buyer agrees to act in good faith to acquire the property and conduct any inspections, investigations of the property that buyer deemed material and or important. And if completion of any of the transaction is prevented by buyer's breach or with the consent of buyer other than is provided in the purchase contract, the broker compensation shall be due and payable by buyer. So that's just saying if you just decide after you've gone through the whole transaction and then you're just like, I'm cold feet and I'm not going to complete the transaction, you're still on the hook for, that's what that says. You're still on the hook for failure to complete. Compensation after expiration date. After the expiration date of this agreement, buyer agrees to pay broker compensation if within blank days after the, so that is one that would be filled in. This is how an agent can protect themselves from, a buyer and a seller colluding and saying, hey, my agreement with my listing agent ends in here in 2 weeks, and your deal ends up in a couple of weeks. You can come and do a deal together. And so, realtor might put 60 days in here to make sure that they don't get circumvented. And when I tell you this, obviously this stuff has all been in consideration. That's why it's already in these in this paperwork. There are people that are unscrupulous. They will work with somebody and work, and at the 11th hour try to circumvent them after everything has been done. You got to realize that we don't, as realtors, we don't get compensated until the transaction closes. And so there has to be safeguards in the contract to protect us. And then listings. Broker shall show property listings that fit the buyer's criteria regardless of the compensation offered to broker by seller or seller's broker unless instructed otherwise by buyer in writing. So I just want to address this, right? So there's still an opportunity for sellers right now to say, hey, I'm offering concessions, okay? They just can't say that they're offering compensation to the buyer's broker or buyer's agent. So concessions, let's just say you need concessions for closing costs of 2%. And let's just say you need another 2% in concessions to cover your compensation. So now you need 4% in concessions, okay? That's what this is talking about. Okay, so all of this is fully negotiable. It always has been. It's just changing some verbiage, and that's really it. It's not as confusing as I think a lot of people are making it out to be. But once again, listing broker shall show property listings that fit the buyer criteria regardless of the compensation offered to broker or seller's broker unless instructed otherwise by buyer in writing. Back to what I was going to say. I would not even look for if a seller is offering concessions or compensation, because you know what? All of that is always negotiable. If that house is on the market, it's looking for a buyer, it's looking for an offer. And all of the terms that we have together to formulate your offer for you is what a seller is going to consider. Now, they might say, oh, I'm not going to pay this or that. But you know what? If their house is on the market for 60 days and they haven't gotten any showings, we bring them an offer that says, and it makes sense, they'll probably pay things that they said they wouldn't pay to begin with. So I'm not going to, I don't want to not show you a property because it says that the seller is not going to pay something that the reality is until they have an offer in front of them, they don't know whether they'd pay it or not. And so, yeah, I've been doing this long enough that I know that, you say, oh, I'm not doing this, and then you sit on the market for 40 days and you're ready to do a $20,000 price reduction. Somebody comes in and makes you a solid offer, and it includes, $10,000 in buyer's closing costs and $10,000 in compensation to pay their agent. All of a sudden, you're under contract. You're buying a home. So down to the next thing, it says buyer instructs broker to negotiate the broker compensation be paid by seller or seller's broker. These negotiations shall not jeopardize, delay, or interfere with the initiation process or finalizing of a transaction. Notice, if buyer decides they do not wish to view property listings unless the seller or seller's broker has offered adequate compensation to broker, the buyer must make that instruction to broker in writing. Once again, I just think it's best practice to go find you uncover all opportunities to find you the home that you might want to live in, and then let me go to work, or let your agent go to work and work out the terms in your best interest. Okay, line 63, equal housing opportunity. Broker's policy is to abide by all local, state, and federal laws prohibiting discrimination against the individual or group of individuals. Broker may not disclose the racial, ethnic, religious composition of any neighborhood, community, or building, not whether persons with disabilities or housed in any home or facility, except that broker may identify housing facilities meeting the needs of a disabled buyer. For more information, consult for housing advisory. Other potential buyers, buyer consents and acknowledges that other potential buyers represented by broker may consider, make offers on, or acquire an interest in the same or similar property as buyer is seeking. So that's just saying that there's all sorts of buyers in the market. There might be more buyers that work out of my same brokerage that are working with another agent, or maybe even me on the same property. Release of the broker. Buyer recognizes, acknowledges, and agrees that broker is not qualified nor licensed to offer advice on financial, legal, tax matters regarding real estate transactions, related services. Broker, if requested, may provide buyer the name of third-party professionals who claim to perform related services. Buyer is instructed to independently investigate all potential third-party professionals and use their sole discretion in selecting which third-party professionals to hire, if any. Buyer expressly releases, holds harmless, and indemnifies broker from any and all liability and responsibility regarding buyer's selection and use of third-party professionals to perform related services, or buyer's election not to use the services or such third-party professionals. That just means, like, I've got vendors, handymen, carpet, window cleaners, window replacement, landscapers. I recommend them to you, but I can't guarantee how they'll perform, if they're going to show up, if they're not going to show up, if they're going to answer their phone, yada yada, right? It's just, I can't do that. And then additional terms and conditions, if any. Alternative dispute resolution. Buyer and broker, the parties agree to mediate any dispute of claim arising out of the relation of this agreement in accordance with the mediation procedures of the applicable state or local realtor association, or otherwise agreed. All mediation costs shall be paid equally by the parties in the event that the mediation does not resolve or dispute all claims. The unresolved dispute or claims shall be submitted for binding arbitration. In such event, the parties shall agree upon an arbitrator and cooperate in the scheduling of an arbitration hearing. If the parties are unable to agree on an arbitrator, the dispute shall be submitted to an American Arbitrator Association in accordance with the AAA arbitration rules of the real estate industry. The decision of the arbitrator shall be final and non-appealable. Judgment on the award rendered by the arbitrator may be entered into any court of complete competent jurisdiction. Notwithstanding the foregoing, either party may opt out of binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other, and in such event, either party shall have the right to resort to court action. The parties shall agree that any and all disputes of claims will be brought in the party's individual capacity and not as a plaintiff or class member in any purported classes, collective representatives, or any consolidation proceedings. The parties hereby waive the right to commence, become a party to, or remain a participant in any group, representative class, collective, or hybrid class collective action in any proceedings, and the arbitrator shall not preside over any form of group, representative, or class collective proceedings. That has all been added in direct result because of the class action lawsuit that led to all of these changes. This really doesn't mean that any further class action lawsuits wouldn't be brought. It's just, this is a protections that the NAR and the AR we're putting up now that says you understand what you're getting into, but realistically, it isn't going to necessarily stop attorneys from doing what they do. Attorneys' fees and costs in any non-realtor association proceeding to enforce the compensation due to broker pursuant to this agreement, the prevailing party shall be awarded their reasonable attorney fees and arbitration costs. Arizona law, this agreement shall be governed by Arizona law, and jurisdiction is exclusively conferred to in the state of Arizona, which means, folks, if you're from Montana, California, New York, or Florida, or anywhere else, and you're used to closing an attorney, and you're like, oh, we want our attorney to review this contract. Your attorney can review the contract, but we're not changing the contract. This is what we use. And a lot of times when you get an attorney involved, they want to change a contract. We are not changing this boilerplate contract. This is what we use, and we fill in the applicable empty spaces, and that is all. Arizona law, copies and counterparts. This agreement may be executed by facsimile or other electronic means, and any number of counterparts. A fully executed fax or electronic copy of the agreement shall be treated as an original. The entire agreement or any addendum and attachment shall constitute the entire agreement between buyer and broker and shall supersede any other written and oral agreements between the buyer and broker and can be modified only by a writing signed by buyer and broker. Invalidity or unenforceability of one or more provisions of the agreement shall not affect any other provisions of this agreement. Capacity. Buyer warrants that the buyer has the legal capacity, full power, and authority to enter this agreement and consummate the transaction contemplated hereby on buyer's behalf or behalf of the buyer party buyer represents as appropriate. And then acceptance. Buyer hereby agrees to the terms and conditions herein and acknowledges receipt of the copy and the place for any and all buyers to sign and broker information there. Now, that was a little long, but I think it's important that we address the fact that these are changes and they are here and now. The next thing I'm going to put up is here we go. This is real, so I just want to post this up here. These are updated fee schedules, okay? So you'll see regarding access and standards of conduct and clear cooperation. Okay, showings, failure to secure buyer agreement with buyer prior to showing listed property. First offense is $500. Subsequent offense, minimum of $5,000 up to a maximum of $15,000 and/or suspension from the MLS for a minimum of 30 days and up to a maximum of 1 year. Folks, do not expect realtors, full-time realtors, people that make their living doing this, not the ones that make 2 sales a year, okay? The ones that make a living do that. Don't expect them to break the rules, because this was such a big lawsuit and had such huge ramifications and consequences that now that it's in there, we believe that there's, you see this first offense, $500. They are not playing around, and they want to make sure that everybody's playing by the new rules. Okay, and then there's all sorts of different for putting in commissions and bonuses in a listing. There's all sorts of people that are doing this already. Big fines is about $500 and then $5,000 for the subsequent. So this is real. If you're a realtor, or if a realtor tells you that they have to sign it, it is because it is a law. Now more than ever, it is important that you work with a professional that is able to convey their unique selling proposition to you, that they can build value, that you feel comfortable with, that that they can take you from first initial handshake through close of escrow and protect you every single step of the way. And at every different milestone, there's things that can go wrong, okay? And so if you made it this far, thanks for sticking around. This is the first in a series of all the new paperwork. So I thank you for sticking around. Feel free to ask any questions you might have, and go ahead and make a comment and share this with somebody that that might be able to benefit from it. Thanks so much, and make it a great day.